but they would have to be more and more careful of thinking, what do I put in my rulings, because sooner or later that may be transmitted, or the information may be transmitted to a foreign tax administration.
So, Denis, perhaps you could start off by telling us, what do we understand from the definition, really, of tax ruling?
Yeah, actually there is no definition given in the law, in the Swiss tax regulations on tax rulings. This is really the result of an administrative practice that has been applied by the Swiss tax authorities for a very, very long time. The taxpayers have no right to obtain rulings, but they usually do obtain rulings. These rulings can cover a variety of subjects, so there is basically very little subject that cannot be addressed by tax rulings. Today, these rulings are strictly confidential. This is an exchange between the tax administration and the taxpayer, and the Swiss tax authorities are not disclosing tax ruling to foreign authorities. They may exchange some information which are contained in rulings, but only when they are specifically requested by a foreign tax administration and provided certain conditions are fulfilled.
Okay. And what will become the legal basis moving forward?
As I mentioned today, we have only an exchange of information based on request. But in recent developments, the OECD standard seems to be always going towards more transparency, so that tomorrow the basic standard would be automatic exchange of information or spontaneous exchange of information. Automatic is that the tax authorities will have to regularly exchange information on predefined subject. Spontaneously is slightly different. The tax administrations will have to exchange information whenever they suspect that there could be an interest to the other state to enforce its own tax legislation. So this is even more efficient, because this is really addressed to specific issues. The legal sources, you can find various documents and agreements, but basically it's first an international convention, an OECD, Council of Europe Convention on Mutual Assistance in Tax Matters. This multilateral agreement does not apply automatically to all signatories, but they would have to activate it on a bilateral basis, which is what Switzerland is doing those days by agreeing with, for instance, Australia, Japan, Norway, that there will be this automatic exchange of information. These two conventions were signed and approved by the Parliament last December, and they will enter into force effective January 1st, 2018, and relate to information that will be gathered from 1st of January 2017. For the time being, it must be said that these legal sources do not really address specifically tax rulings. They may contain a broad legal basis for future exchange, but the focus for the time being is more on exchange of information on bank accounts, which is really the point. The guidelines issued so far by the OECD have identified 6 types of tax rulings where information must be exchanged, and really I have to read you the list because I don't know them by heart, but really the first are rulings related to preferential regimes, as I mentioned, auxiliary holding regimes, and in that respect Switzerland also took some advanced steps in the frame of the tax reform number 3, which is a federal law being discussed before Parliament those days, which will presumably or most likely enter into force 1st of January 2019. And this law will abolish certain preferential tax regimes like holding regimes, auxiliary regime, principal company regime, so that all the rulings which have been issued on confirming these preferential regimes would automatically become obsolete at the end of 2018, when the new law will start to apply. But the timing is a little bit unfortunate, because remember, exchange of information is from 18 based on 2017, so that these rulings, which will still last for 2 years, will probably have to be covered by the exchange of information. But at least they will become obsolete. But there are plenty of other rulings that can be applied on different subjects. The way information has to be provided is still being discussed, but for the time being, it doesn't seem that the guidelines will impose an exchange of the ruling as such, so transmitting the whole documents. For the time being, the Swiss tax authorities may have to inform another tax administration about the content of the ruling, summarizing the main points, and possibly, perhaps based on request, transmit the whole ruling, but it doesn't seem to be yet provided. And in Switzerland, there will be further legislative efforts to be made to really accommodate these spontaneous exchange of rulings, which presumably, or which really appears to be unavoidable in the future. And that would, of course, be a big change for Switzerland, for companies which have relied on tax rulings and which probably will continue to rely on tax rulings, but they would have to be more and more careful of thinking, what do I put in my rulings? Because sooner or later that may be transmitted, or the information may be transmitted to a foreign tax administration.
There's obviously a lot going on, a lot of changes, and for the whole point of transparency, I guess. But thank you so much for coming in today. It's been an absolute pleasure and really informative. We now feel as though we know what's going to happen. Thank you.
Thank you for welcoming me. Thank you.
Thank you. Okay, well, that's all from Denis and myself for the moment, but keep on clicking back to Dukascopy TV. Goodbye for now.